everyone. If you please stand and join us for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
All right, good morning, everyone. It is November 24th. This is the Broadwater County Commissioners' Business Meeting. It is 10 o'clock, and before we get started, again, we do have an open meeting policy. That policy does follow Robert's Rules of Order. The purpose of this policy is to open all public meetings to all Broadwater County citizens. We have a fiscal and fiduciary responsibility to conduct county business as efficiently as possible for all our citizens. Commission meetings are recorded and are on YouTube, so please state your full name prior to any public comment for the record. Any separate conversations need to be removed from the meeting and conducted outside. Outbursts will not be tolerated. Public comment will give each citizen who wishes to speak an initial 3 minutes to do so, and all comments should be directed to the board chairman. With that, do we have any public comment this morning? Public comment? All right. How about Montana Minute? Franklin?
Well, I'll start out, Elaine will elaborate on it.
I can hardly wait.
Football team, so I'll let you do the rest of it, Elaine.
I hope I don't cry. Hats off to the football team here. They won state Class B championship. They have never won that championship the whole time they've been in Class B. When we were Class C, it was won 2 or 3 times, but never as Class B. So hats off to the team, to the coaches, the staff, and all the people that were there. We had more people there from Broadwater County than Huntley Project did. And Coach Rouse's dad is a doctor and so has a little bit of money, and said if they won, he'd take them to dinner in Billings. So they all got to go to Gussex for dinner. And then, I'm not positive who set it up, but the fire department and all met them at the bunkhouse bar. Oodles and noodles and noodles of cars, lights flashing, cops flashing. They went to Watson's and set off fireworks, and then when the team came into town, they were setting off fireworks at the head of Main and down by Town Pump. So everybody's proud of the boys.
Absolutely. My Montana Minute is ditto. Can't top that. Anyone else have any Montana Minutes this morning? Bob?
I just left Coach's Row and Horn, and by accident, I ended up with a couple of pictures that they want to send to an official that they know down there for a fumble that was not called a fumble. We've got the fact that it was a fumble.
Really?
Travis says that's a 14-point swing in the score. But they can't all be perfect. But it was neat.
Yeah. Did you have the bus? Drive the bus?
Yeah, I drove one bus and Gary Olson drove another one for the adults.
A good bunch of kids.
Yeah.
It was a good group.
It is. You know, we've got pictures of them. When Jaden, our grandson, were preschoolers. In the middle of the summer, Jaden decided he wanted to have a Super Bowl party. So they have a very large backyard. So TJ got some PVC pipe and built them uprights, and they had a big Super Bowl party. And there's pictures of those kids that are still playing today, playing football, thinking they were Super Bowl.
Any other Montana Minutes this morning? All right. So, first order of business before our first appointment is the minutes from November 17, 2014.
Make a motion that we approve the minutes of November 17th, 2014.
These were sent out last week for our review prior to the meeting. It's been moved and seconded to approve the minutes of November 17. All those in favor, please signify by saying aye.
Aye.
Aye, motion carries. Thank you, Ann.
We just have to say, Ann, we appreciate the fact that you get on those so quickly, all the other work, and do a good job of them.
We usually get those on Monday or Tuesday, so that's pretty impressive,
Never Wednesday, it's always before.
right? Yep. All right, we have just a little bit of mail here. This is a failure to monitor advisory for the Silos Recreation Area. I brought this forward because it is an error. I did contact DEQ. They don't have anybody at the campground. So from October until April, until they open, this is not required. So this is just one of those things that they send out as an automatic every year, and then say, yeah, please disregard.
Probably computer generated.
Probably, yeah. This is from the Montana Association of Counties, the Joint Powers Insurance Authority and Joint Powers Authority. This is from our insurance company. And what it is an endorsement changes to the policy for covered vehicles, damage endorsement, and contractors' equipment endorsement. Next, we have a paycheck card. I don't know if you got one of these from Debbie for being absent last week. Just wanted to make sure you had one of those, and payday is next week. Thank you. Next, we have, this is from WWC Engineering. And this is just kind of a heads up for us. We each got these in the mail. I left yours in your mailboxes. Call before you dig, utility locates, and this is just a reminder to call 811 before digging. From the Department of Public Health and Human Services, we have a letter regarding the alcohol earmark tax distribution. And the amount stays the same. You get paid quarterly, and it's $2,028 per quarter for a total of $6,084 so far. The fourth quarter payment will be made in the fall of 2015, and it will meet or exceed the required 20% statutes provided by MCA 177502.
I wonder if that's up or down there, about the same.
I don't know. Next, we have from the Montana Fish, Wildlife and Parks. This is a letter regarding deer management plan, and this is for the city of Roundup. This does not affect Broadwater County, but if you know someone who lives there, and they'd like us to comment on their behalf, they can certainly address the commission about that.
You must have a deer problem by town.
Yeah, I'm guessing. This is an invitation to a public meeting, water rights negotiating session. This is between the Confederated Salish and Kootenai tribes, and this is water rights compact for that commission, December 1st.
Have you been watching that computer?
A little bit. I'm by no means any kind of an expert, though. I think that's
Oh,
a
no.
complicated issue.
Maura,
Yes, sir.
that's gonna end up right in the lap of the legislature this session, pure and simple.
I'm sure.
People I know on the Flathead are just up in arms over this. And it will set precedents. And so that's why they have to be very careful about it.
Oh, yeah, yeah. And I bet there's a lot of emotions going around too to complicate things. Yeah, that'll be an interesting one to watch.
And lots of
what
history.
happens. Yeah, no kidding. So if anyone's interested, it's in Missoula, it's at 3720 North Reserve Street, 2 o'clock at the Hilton Garden Inn on December 1st. So with that, our first appointment is courthouse and employees, work environment, and safety discussion and decision. I didn't know how to word this because I want to protect this particular citizen's constitutional rights and show him as much respect as we possibly can. But I think it's our duty as the commission to be thinking about the safety of some of our employees. Currently, I understand that Mr. Wright is in jail, and this is due to something that escalated from a meeting in which he tried to place me under citizen's arrest. A deputy escorted him out of the meeting, and there was an altercation in the hall of some kind. So that's not the reason for this. The reason for this is that this behavior it restarted. It was a problem years and years ago, and the story is that he was banned from the courthouse from a previous commission. There's panic buttons throughout the courthouse that were installed years ago, presumably for the same reason. Last June, or June 2013, things just started to ramp up again. It's been escalating ever since. So, I have here a memo from the county attorney talking about rights and responsibilities of the commission. I also have here a memo written by an intern to that office in which he talks about the Montana Supreme Court's interpretation of federal law regarding removing an individual from a public meeting for disorderly conduct or disruptive conduct. It does not violate the First Amendment so long as the regulation justifying removal is narrowly tailored to serve a significant government interest and is content neutral. Furthermore, anyone can be removed from a meeting if they present clear and present danger that the speech will bring about the substantive evils that government has a right to prevent. When a citizen's conduct actually sparks a larger public disturbance or creates the risk of such a disturbance, the law is clear. Neither the individual right of access or public meetings nor the First Amendment right to freedom of speech allows for disruptive, abusive, or incendiary speech, and those presiding over public meetings are in no way obligated to tolerate it. The exclusion of disruptive individuals from meetings of a governmental agency is expressly condoned by MCA 45-8-101G and is reinforced by federal constitutional law. And then there was an issue where a person was banned, this is Stedbury versus Bitterroot Public Library. Patron was banned from the library because he would not adhere to not being disruptive in the library. That was upheld by the, I believe the Supreme Court, state versus Stedbury. And the final paragraph is in Montana, where the conduct of a private citizen either actually creates or creates the risk of a larger public disturbance, that citizen may be removed from a public meeting. That citizen may be then charged with disorderly conduct. Private citizen may also be excluded from state property so long as the state has lawful and non-discriminatory reason for exclusion, and the citizen is aware that they no longer are allowed to access to the property in question. So with this in mind, this is a letter that I would like the commission to submit to Nick Murnion and the county attorney. It does not speak to the money wasted so far this year by Mr. Wright's behavior, but I think as the commission for the county, we need to be cognizant and react to the fact that 7 employees have written complaints of being threatened, harassed, intimidated. Several elected officials have been so treated. Members of the public have been intimidated from coming to these meetings, although they have been better lately. So this is, I would rather not have to go through the process of charging him with disorderly conduct. This is also for his protection as well, and there are steps to ensure that he still has his full right to participate, but we are protecting our employees from undue inappropriate treatment. Did I see a hand go up? Okay. So,
It's in her ear.
all right. Just out of the corner of my eye. So I don't want to, I think this needs to be the commission working together for the safety of the public, for the safety of our employees. If you look at one day's monetary waste on what has happened with Mr. Wright, taking one Monday and taking the people that he threatened on this particular day, the people then they talked to, the fact that they called dispatch, they called the county attorney, accounts were written by each of the individuals describing what had happened, and then he was escorted later out of the commission meeting, so now you're talking deputy time. If you have taken all that, it equates to $108 that was wasted that day on this one individual. You multiply that by 52 Monday meetings a year, not even including the fact that we have occasional Wednesday meetings, you're looking at $5,700 per year that's wasted. That's not in this letter because it really isn't a reason, it's just frosting on this cake. The thing that we need to be aware of and react to is the safety element. He goes into offices and yells at our employees. He has trapped employees behind their desk to get out from under their desk. It's, they're looking at reaching out physically to this gentleman. That's not a good position to have our employees in. So that's what I think we should do, but I would like the support of the commission.
Well, as I'm the old lady on the crew, I've been here for a long time, and this is not anything new. He was banned a few years ago. First, all the different buzzers went in to connect to the sheriff's office. I clerked for the commissioners, and they were afraid of what might happen. And I don't think that our employees deserve that kind of treatment, or anybody else in this county, for that matter. I think that utmost importance is to protect the people.
I agree. The other thing is whenever there's been 129 shootings in schools alone, not including malls and federal buildings, since Columbine. We don't hear about it on the news anymore because it's not as shocking as Columbine was. But the one thing you never ever hear when they interview people who know the shooter, they always say, we never thought he'd do anything like this. We are not experts here in the field of mental health. we do not have the professional capability to make the determination that this escalating behavior does not prove a potential harm to anybody in a county building. Until we get that assurance from somebody who is an expert in that field, I do think that the past commission was right to be leery, and I think we are too.
Definitely.
So, yes, Roger.
I know it would cost a whole lot of money, but, well, not a whole lot of money. But as a former investigator, one thing I think you're missing in all of this is a psychiatric evaluation to determine whether this person is mentally healthy or not, to find out what's motivating him. With a psychiatric evaluation, I think you'd stand on much better ground. I don't know if, since he's in jail, is the sheriff still here? No. I don't know if it can be court ordered or not. But at least then you've got an official opinion from a psychiatrist as to the potential for him.
Thank you.
My observations is that his actions to this point are really not rational from what I've seen when I've sat in this room. And I myself had to go out and quiet a conversation he was having with your DES person. And as a former investigator, I've had a lot of training, and it took all the training I could. It took my training to, how do I want to put this, to talk him down, to get him quiet. And that's because I've done it quite a bit, where your employees here don't have that expertise at all. I've said enough.
Appreciate your input though, Roger. So, I think the other thing with this is I think we should be on the public record for our employees, at the very least letting them know where we stand as far as their right to safety in their place of work.
Not only our employees, but the public coming into the building.
Absolutely,
I think
Yeah.
that's, we owe it to our people.
yeah. Franklin, any comments, questions, concerns?
Well, I know too, well, John is, he corners me and talks, I've never had a problem with him. Of course, I've dealt with a lot of people through the years and different things, so. But I know he does get disruptive. Sometimes, but that's, this last thing from what I understand, he wasn't escorted out of here. He called the sheriff's office to send the deputy over. And then what took place out in the hall, I read the deputy report and everything there, that's completely different from what you're saying. And from what I understand, I think he was just gonna serve his time out for no driver's license or no insurance, something like that. It had nothing to do with that.
No, you're right, the two situations are different. But the fact is, he is in jail right now, which is why he's not here. But that is just a side note. As far as doing something about the disruptive behavior, the fact that he stirs up a meeting or has previous to today, numerous times, that he has been escorted out, probably an average of twice a month. Yes, that one particular day, he was did call a deputy who did escort him out of the meeting. But I think, I think glomming onto a tiny detail from one day when you're looking at 18 months, I think that's what I'm concerned about, is the pattern of escalation. So,
Well, I'm not supporting him at all. I just think some of the things, and then some of that stuff you're talking about, $5,000 it costs a year, so I mean, that's outrageous.
yeah, I agree. So, do we have a motion on this, or to proceed, to take this to Nick Murray and County Attorney?
I'd want to talk to the county attorney
Mm-hmm. Yep.
before anything's done.
So is that a motion then?
That we table this and talk with the county attorney.
Well, what I'm asking for is a voice on record that we are either going to address this issue as directed by the county attorney and Nick Murnion, or we are going to be on record that we do not support safety in the courthouse or for our employees in their place of work. This is not anything more than, I want a united commission to request to work with our county attorney and Nick Murnion in potentially banning this gentleman from our meetings or addressing his behavior.
Also move.
I'll go along with that. And that it's, actually, this table right now,
No,
and
it
we
is
work
not
with the
taken.
county attorney. Well, we have a county attorney.
Oh, Franklin, that's ridiculous. Is that a second to the motion, to Elaine's motion?
I'm support, yeah.
Okay, it's been moved and seconded to go ahead and proceed then in working with our county attorney on the issue brought up by the disruptive conduct of this individual over the last 18 months with a goal of perhaps banning him from the Broadwater County buildings. All those in,
Can I add one thing?
yeah,
For the protection of the public and our employees.
thank you very
I think
much.
that needs to be there.
Absolutely, I accept that friendly amendment. So with that, all those in favor of the motion, please signify by saying aye.
Aye.
Aye, motion carries. Thanks, Ann, I'll give that whole staff. And with that, we're at 10:30. Scott Dunning, lead coordinator, Carla Bossi, county attorney, non-compliance policy and discussion.
Morning. The reason I kind of asked to get on the agenda is with the help of Carla and the weed board. We finally have an updated weed policy, a non-compliance policy that we'd like to submit. And it's in conjunction of the 2012 Montana Code Annotated legislation change to the non-compliance policy. This makes it a lot more official and gives us a lot more backbone to stand behind when we actually have a non-compliance issues and we actually have a policy and procedure to follow that can be upheld by court or the commission or however it goes. So I just wanted to kind of present that to you. And in this, one thing that we did do, and this is as requested by the weed board, there's a friendly letter that we would like to be able to issue before we ever start the non-compliance policy. Just kind of as a way to educate and outreach to the public. So, yeah, and that's kind of the one thing is that it's gotta be a formal written complaint, before we can actually start a non-compliance policy. But depending on the severity of the weed issue or whatever, we wanna be able to give the public or the landowners a chance, by writing this friendly letter saying, hey, you have weeds on your place, state or county listed noxious weeds, you have to control them. We would like to help set you up. And then if they don't respond back to us, then we go into an actual formal non-compliance policy.
Do we have
procedure.
that many, this comes about?
Yeah. I get probably 1 to 2 phone calls a week all summer long for about 5 months. And so,
I thought this was already in place pretty much.
well, it is, but we don't, without the adoption of a policy like this, we don't have anything that's upholdable by law. I mean, you have to go through, it's not back through the commission or the county attorney or anything, it's just backed by the state. It's state mandated, but we don't have a true policy on how to report and comply and actually go through all of this. And this is what we're doing now, is we're setting this policy so that I, as the weed coordinator, am now the agent of the law, basically, in stating that I can take complaints, I can keep on file, and we do have an actual policy and procedure that if it comes into the non-compliance, and I have a backbone to stand on, I guess you could say. And it just basically states that, you know, we can be, that we will be reimbursed for our efforts as done.
And Jen, I don't know if it'd be proper not, but have Corey come up and listen, because he's the one that's gonna have to enforce this.
That's why I invited him to the meeting, and I think he's right there listening.
Yeah, if you'd like to
So-
come up to the table, you're welcome. If you'd like to stay there, you're welcome
I'm
as
fine
well.
here. I'm fine here. I'll have to read it, obviously, I haven't read it yet, but that's,
Just to clarify a few things, the process is set forth in statute, so the commission doesn't have to vote on it, it's there. The weed board has approved putting this in place, and so this is sort of more informative to let you know. Scott came to visit me shortly after I got here in 2012 when we started talking about this. At the time, there was a statutory process in place, but there were some issues with it. Those issues were addressed in the actually in the 2013 legislature, and amended. And so we, rather than recreating the wheel, we kind of waited for a larger county who put the the resources and time in, and we essentially got a model policy from Gallatin County, which had been vetted through their legal department, and we forwarded it to NACO to make sure they had no concerns or questions with it. So that's all been approved through the entities, I guess, that would have knowledge of whether there was an issue with the way it was done. But I have a great deal of confidence in Marty's office and the fact that they got this right. So we basically just borrowed their policy and you know, specified that it was Broadwater and tweaked a couple of little things. And then again, Scott requested that I review this friendly letter that we'd like to send first, just to sort of try to make it a very amenable, friendly, working relationship. But there is a process available if the person does not comply with working with Scott on the issue. It does rely entirely, however, upon the county attorney's office's willingness to pursue what's allowed under statute. So hopefully Cora will be willing to pursue those cases, few and far between, I think, that will actually go that far. I have a feeling that Scott will be able to work with most folks on a voluntary basis. It's, I think, misdemeanor level with some financial penalties, and so I think most folks are gonna wanna avoid the possibility of that process coming into play and work with us. Basically, it allows for them to either provide a mediation or remediation plan to Scott's office for approval, or to give Scott's office the authority to set up weed treatment for them, although the landowner does have an obligation to recompense the county for the cost of that if they go through the weed department.
Plus, it states in here too that, you know, if we go into the non-compliance policy, once we get upon treatment, then they're responsible for all costs of treatment, plus a 25, and lawyer fees and all that stuff, plus a 25% admin fee. So just kind of as an example, I had a legit complaint here a while back that several different landowners and people had come in and submitted letters of support, and it was basically a field that had been mishandled. I guess it was probably 80% of Canada thistle and cheatgrass. We tried to work a deal out with them. By the time it was all said and done, according to this, it would have been approximately a $25,000 bill that the landowner would have been, you know,
Wow.
distributed. And that was on about 200 acres of, you know, dry farmland, which honestly, I don't know many landowners that, you know, especially farmers or ranchers, you know, in this day and age, it can handle a $25,000 hit and things like that. And so I think, you know, that's where the working with them comes in to play, you know. We don't want to go out there and just be Mr. Meany, I guess you could say, but we do have a law that we have to abide by.
Well, the bottom line is, it's not only 25,000 here. What is the loss of crop? Money out of their own pocket that shouldn't happen.
And I think, you know, one of my biggest complaints is, are all the subdivisions, you know, you get these 20-acre lots, well, there's, you know, absentee owners or people that are, you know, gone 9 months out of the year, don't even realize that they've got this issue. And this is a way for us to come in, and I mean, I've had to deal with this in the past, where a piece of property is going up for sale, and they've got a major weed issue. Well, state law also states that you know, that the realty agency has to notify any potential buyers of this weed problem. I don't know how many times I've come to these people and say, hey, you're gonna have to work something major out with us because you've got a weed problem. We've got a non-compliance policy on you, except it didn't have any backbone. You know, it could potentially devaluate that piece of property by a lot of money, depending on the weeds and the treatments necessary.
I also think in that vein, Scott, this has potential to be a nice service that you're providing. Someone who is an absentee landowner who has their property up for sale, I think would rather receive this friendly letter than be surprised when they can't sell the property or it decreases in value. So I think there's two different ways to look at this. I like starting off with the friendly letter. I think that's a great first step. And I know you've been working on this for a long time. I think it's a great idea.
I have to agree.
Any other questions or comments at this point?
No, I'm 100% behind it. A good example we went through here last spring was this drainage issue up here full of thistles. You know, so it affects multiple people. And I've got calls too. I know another one that there's thistles blowing all over now, you know. And these subdivisions, that's the biggest thing. These people, they buy these 2 or 3 acres, especially in that south end of the county, spending CRP, so the old grass is standing up there high, you know, and the first thing they do, they put from 2 to 5 horses on there, and about 3 months, it's just like this table, it stays that way, the only thing that's growing there is Russian thistle and some kosher. But anyway, yeah,
Well, and this doesn't pertain to like your kochia and your Russian thistle and things, because they're not state listed weeds or county listed weeds. This is strictly
I
the
think you can
state
still
or
step
the-
in though, when it's a problem, be a nuisance problem, nothing else, I mean.
I had an issue on that, with that, dealing with that this year, with some complaints, because
On the Russian thistle?
the Russian thistle was so bad and it was blowing and everything. And so I went through the Department of Ag and they said your first step of anything on dealing with that, unfortunately, is a safety issue, or, you know, as a county safety issue, or as a fire danger. But there's been a lot of different county weed departments that have asked about kochia and Russian thistle. And I don't exactly know what the issue is, but I think there's some native thistles that are so closely related to Russian thistle that they can't actually, without being able to provide a DNA sample, they cannot allow that one to be listed. I don't know exactly, but I know that they went through big legal battles at the state, so anytime we're dealing with that kind of an issue, all we can do is say, okay, it's a, you know, it's a health issue, or it's a safety issue, or it's a fire danger.
Fire, safety. You'll see it on the highway, the traffic dodging those big old Russian thistles coming down the highway, and the people are swinging all over.
Oh,
You
yeah.
know, it's-
They're bad ones, but this one, you know, are the ones that have been, you know, the ones that we're going after, are the ones that are shown to cause significant economic damage to the community. So, you know, things like your Dalmatian toad flax, or your musk thistle, you know, black henbane, so.
That's the problem, they don't cause the big problem that everybody sees, you know.
Yeah. So, like she said, one thing that I do wanna mention, you know, too, is that, you know, it took us a long time to come up with an agreeable policy. This one was borrowed from Gallatin County, but it took their lawyers, I think, and I was talking with Gallatin County Weed, it took 3 lawyers 6 months to get this policy to where it was upholdable too. I've also dealt with the Gallatin county weed, and they said that before it ever gets to non-compliance, like 90% of all cases that are brought before them, they'll get right to that non-compliance stage, and 90% of them are dealt with and handled before they ever go into that last step. So, I think this is a good, solid foundation, as where to start and start working.
I think it's a great step. Any other comments from, or questions from the commission?
Would you like a motion?
Yeah,
I'll make a motion that we adopt this weed enforcement policy.
Yeah, I'll second.
it's been, actually, before I call for the vote, is there any public comment on this or discussion on this particular issue or questions? Bob?
Not on that one in particular, but Scott wants something that's real good reading, something that I discovered when I was going through my master's in an early Montana Department of Ag annual or biannual report. There's a statement in there that they eliminated Russian thistle from Montana.
Oh, good to know. Let's not put that in writing. Thanks, Bob. Any other comments, questions,
I
Corey?
have a question on the procedure. So is this the first time that the policy's been looked at? Like, do you guys ordinarily do a hearing and then wait for the public to look at it, or do you just, can you do it all in one? What ordinarily would you do in this situation?
This is actually not something that this is more of a courtesy vote. So in this case, no, we haven't seen it prior. This is actually Scott's purview as the supervisor for the department working with the county attorney. But if this were something where it was a policy that would be something that we are responsible for, we would actually have a public hearing. We would notice it in the paper. It would be in the form of a resolution. About 90% of them are. This one's a little bit different than that because it's already state law. We're just saying officially we're going to follow and put teeth to state law. So this is a different process than you'd ordinarily see.
Well, and his board is supporting this.
Right.
Here's what we did.
I mean, his board, I'm sorry, is supporting this.
Oh,
I have water if you need it. So
see,
it
I thought this
has,
already was in effect, but I guess it is just the state.
It was as of, I think the statutes became effective July 1, possibly before. I didn't look at the effective date. There are sometimes different dates for effective dates, but the weed board just wanted to have it, essentially to have a policy that draws on those statutes and is set forth that people can come and ask the weed coordinator what's the policy in Broadwater County and what are the ramifications, et cetera. So yes, it was in effect as soon as it was effective after the legislature, but we're just finally getting to sort of putting it into our own.
I thought it was even back years ago, it wasn't then, huh?
It was, but they changed it in
Didn't-
2013.
Okay, but years ago, and right, more about it, the county maybe just did the threatening that they don't take care of something.
We handled it more as an education thing because there weren't enough teeth to really follow through on it, and 90% of the time, education would work.
Mm-hmm.
Lots of times you just had to point it out to people, you've got a problem out there. Oh, okay.
Nowadays, and that's where you're seeing a lot more of it, and it's statewide, not just countywide, or whatever, but with the expansion, and the growth in the state, you're seeing a lot of these subdivisions and a lot of these issues where, they have that big boom, and then now all of a sudden, there's so many vacant lots and stuff. Some of them you say, you know what? I'm already bust, so go ahead, do whatever you could until we get this in place. Now we actually have backbone to say, okay, comes down to it, we can.
thank you, Scott. Any other questions, concerns? All right. It has been moved and seconded to support the Broadwater County Weed District Noxious Weed Enforcement Policy. All those in favor of the motion, please signify by saying aye.
Aye.
Aye, motion carries. Again, it's not on the agenda that we will be voting on this, but I do think it's okay to have it on record that we do support this. So, thank you, good work, both of you, and I think you were smart to wait till the county put it all together.
They have
A little bit.
a number more lawyers than we do, so it's no point recreating the wheel.
Absolutely.
And they were very happy to share as well, and I'm sure any of the larger offices will be happy to share with Mr. Swanson anything like this that can help him, because it's difficult to try to carry the regular caseload and do a lot of work into separate areas like that.
What'll be interesting is, to the extent that NACO adopts this, and it's discussed at the next conference midwinter, that this is available. And Corey, I want you to also be aware, just for reference, Ann used to be the weed coordinator, and Bob used to be our county extension agent.
And weed coordinator.
And weed coordinator, yes. So, anything else from you guys?
No?
All right, anything else from the board? Okay, thanks very
Good
much.
job,
Good work.
guys.
Yeah. So, 10:45, Carla Bossi, County Attorney, Teamsters audit results and discussion. And, you know, I think these were all supposed to say decision, and we just missed that.
It's okay though, that unfortunately, I still wanna meet with you and kind of give you an initial presentation, but I'm still waiting to hear back from Teamsters Council with an exact dollar
Yeah,
amount that the county is looking at with regard to this issue. But just to kind of get you, you may remember around this time last year, maybe it was last month, we had a random audit of our Teamsters insurance coverage by the Teamsters. That's in our contract that they can come and do an audit. So they came and did an audit, and the audit basically comprised of them picking a random period of time, and I believe we entered into this contract with them in 2009, and they chose the period of time from January 2011 to end of 2012 to audit. And the audit is designed to look at, are we contributing into the Teamsters Trust, which is the large, pot that the money goes into to cover the individuals who are participants in the plan appropriately and according to our contract. And so they came and they spent, I think, a few days here with Debbie, asking her to pull various records from the employee files. And then we received a letter from them. I'm trying to recall the exact date of the first letter, but it was sometime in, I think, late spring. Nope, January 24, 2014, and the letter was sent to Debbie as the accounting manager. And it was a copy of the recently completed audit. So they looked at records while they were here, and then they went back and mulled over those records and checked their records. So for a month or two there, they were working on that and then sent us this letter. And at that time, again, the period examined included payroll records from January 2011 through December 2012. And at that time in this letter, they advised us that their audit findings noted unreported hours resulting in an underpayment of $79,667, with the addition of liquidated damages and interest in the amount of $32,793.60, auditor fees, which are granted as part of the contract we have with them, $3,536.83, for a total due to the trust by Broadwater County of $115,997.43.
Can I get you to say that again? I mean,
The total?
No, right from the beginning, what they found.
Okay, what they're saying
I'm
is,
sorry.
it's all right, what they're saying is the enclosed audit findings note unreported hours. So just to clarify for you, that means what they were alleging is that we had not properly calculated the hours reported. So of course, contributions into the insurance are based on, well, they're based on our personnel policies and our contract with the Teamsters, and that's where it gets a little hairy, and I'll get into that in a second, but what they're essentially alleging is that we had improperly calculated work time hours for certain employees such that we did not contribute for them to have coverage when we should have in the Teamsters position per our contract with them. So somebody like any of you folks who are on, electeds who are on a salary or whatever, we're just considered full-time and we get a contribution made for every month that we work into the Teamsters Trust for coverage. But we have part-time, seasonal, and temporary employees who may or may not work the 32 hours required per week in order to be considered as covered employees. And again, what this all ends up getting into, and I'll get into that again in a second in a little more detail, is a difference of understanding between ourselves and the Teamsters as to when coverage applies to employees. So essentially at that time, they were telling us we unreported the hours, resulting in this underpayment. Plus, according to their contract and ERISA laws, they're allowed to assess liquidated damages for the failure to pay timely, interest, of course, on the failure to pay timely, and auditor's fees for the process of the audit itself. So the total that we were advised in January 24 of this year that we owed to the trust was $115,997.43. So Debbie, of course, forwarded this to me immediately in despair, and we started to work on the issue. So I contacted counsel. This letter was from Mark Coles, who's an account executive with Teamsters Trust and who was involved in the original contracting process in 2009. But I contacted Noelle Dworsky, if I haven't butchered her name. She's an attorney with a law firm in Seattle, Washington, who represent Teamsters. And so we've been in communication on and off between January and about a week ago I had an email from her and she thought she was gonna have me a definitive number before this meeting with you folks, but she didn't get back to me with that number, so I will have to ask for a follow-up agenda item on the next meeting so that I can provide that to you. But essentially, through a lot of sending of information back and forth, working with Debbie, having her recheck some of the information, negotiating with counsel for the Teamsters, we have much minimized that original amount. It's been whittled down quite a bit. I can explain to you essentially from what I can tell, and it's kind of to some degree, relying on the memories of employees who were involved at the time and are still here. Because, and this is gonna be like a sort of addition to this conversation, is document. We really need to be better in Broadwater County about keeping records, or at least this experience has made me aware that in some departments there was not proper documentation saved. Essentially, in looking into this, Debbie and I went into commission files and accounting files to see what the history was of the contracting process with Teamsters, and there's not really much there that was helpful to us. The institutional understanding of Broadwater County through Ms. Kelly, Ms. Rouser, and Under Sheriff Naff, who communicated a little bit with Brooke Dolan in my office. Brooke has been involved in insurance issues as an employee member of the committee for quite a period of time, so she also verified. The understanding was that when we made the decision in 2009 to switch coverage from Mako, who was originally our healthcare provider, to Teamsters Trust, which we are eligible for because of the Teamsters unionization of the Sheriff's Department, that the agreement was that we had a couple of employees, 3, who were not getting coverage through the county because they had coverage through their spouses. And so that they would be grandfathered as well into, even though Teamsters typically does not allow any non-participation of qualifying employees, that they would be grandfathered because they already had that benefit. The county, I believe, put some money into their AFLAC, and since they don't get an insurance premium, which other employees get the benefit of. So that would be included, and that our policy as to when a person is eligible for health insurance coverage, if they're part-time, seasonal, or temporary, would govern. But we didn't put that, it's not in the contract. Nobody here at this table was involved. It was, at the time, Chairperson Venice, who signed the contract. The contract was largely put together by our former finance director, Natalie Wenzel. She was the one who communicated with Mr. Coles. Under Sheriff Knapp had some involvement in it. But the terms that were apparently discussed and shared verbally with other folks in the county were never put to writing. And the issue that the position the county is in is when there's a contract dispute and you go to court on that, it's what's in writing that pretty much governs. The claims of oral agreements don't hold weight. And so we talked about this with outside counsel to verify what my opinion of it was when I looked at it, which was, we're kind of out of luck here. We don't have a defense because we have nothing in the records that would actually, no email communications. I mean, an email communication, which would have been a written amendment to the contract, would have been something we might have been able to present to court and say, wait a second, this is what they told us was part of our agreement. We don't have any of that. We just have the contract, which the language is very spare, and it does not at all address the issue of grandfathering of the 3 employees who we all believed would not have to participate in the program, nor does it address the issue of Broadwater County's policies with regard to when people qualify for insurance coverage versus Teamsters' general demand, which is what they apply to all participants in the program. There's nothing in writing that says that they made that agreement with us. So the default is that we agreed to what they impose on all of their participants. In any case, again, going through and you see some of these packets that I have in this file are, we went back and pulled time cards, time sheets, put together various information, and we're able to negotiate with Teamsters Council to remove some of the employees. There were some errors in their audit because they're not perfect either, or their interpretation or understanding of our documenting. The way it works here is when somebody terminates employment, they get a cash out of sick time or vacation time, etc. That's per our personnel policies, but they haven't actually worked in that time period. So there were some months where Teamsters, because of payroll, thought that somebody worked, and we were able to clarify to them, no, that was a cash out for time that they had banked when they terminated employment. So we were able to work that out. The agreement that I came to with Ms. Dworsky, and what I'm waiting for is her verification that in meeting with her client, they have also agreed, was that because we were able to provide proof from 2 of our employees who still work for the county that they had coverage during this period of time through their spouse as they have asserted in asking to not participate. And this is a liability concern. Teamsters is concerned that if somebody was not covered during a period of time when they should have been covered, and something happens that could somehow come back and bite them, they need to have proof that somebody had coverage if they're not participating in the program. So we were able to provide that proof for 2 employees, and the request I made on behalf of the county is please amend our contract going forward such that these employees can continue to be in that status where, as long as perhaps on a yearly basis they provide proof that they are indeed covered through an alternate coverage, that Teamsters won't require they be covered. We will not be able to offer that going forward. It is not standard or typical in their contracts. So even in the hopeful situation that they will allow it for these two employees, we won't be able to offer that to any future employee to say, if you have coverage through your spouse, you don't have to participate. That's not going to be on offer. One of the employees who was in that position terminated employment, and I have not been able to locate her. We had a forwarding address in the Midwest, sent a letter, did not get it returned, but did not get a response. I've tried through looking up listings with similar last name to see if I could track her down. So essentially, I let Ms. Dworsky know that so far as I understood, she did have coverage, but we don't have, something from her provider to prove that. So that's another issue that we're waiting to see whether Teamsters will give us grace on that or request that we pay the premiums for the period of time. And it's important to understand that one of the issues I had in mind in negotiating with them was they looked at a two-year period for their audit, but 2 more years have taken place pretty much since the audit finished. So in looking at this, we're trying also to see if we can curtail any possibility of additional exposure for the county for those 2 years that weren't actually audited, but where we were following the same practices, which we always in good faith believe to be proper. And that's important to understand, that they understand that the county was operating in a good faith misapprehension of the terms of the contract. There wasn't any attempt to defraud, et cetera. Because of that, one of the other issues that Ms. Dworsky is raising with her client is their willingness to reduce the interest in liquidated damages to which we are exposed. My understanding is because of ERISA law, they can't completely negate the interest. The law prevents them from doing so, but they can use some discretion in how much of it they will actually impose on us. And again, because we've whittled down some of the claims of their audit and gotten some of those removed, some of that would go away on its own. So right now, again, basically what I'm waiting for to hear from her is what is the actual number that we owe to Teamsters, and are they willing to go forward? Debbie engaged with me in the last telephone conference meeting that I had with Ms. Dworsky. She understands now she was always working under the direction that she had been provided by Ms. Wenzel from the beginning of how you calculate and when you contribute. She understands now that that's not correct and that she needs to calculate and contribute per the standards that Teamsters has in place in the contract. So we're not making the same mistakes going forward, but those mistakes were made in the past. Again, I don't have an exact figure to let you know about. It's not really an issue of, I suppose you have the possibility of voting on rejecting the hard work of the legal department in negotiating this down and saying, we want to take it to court, but it would be my strenuous advice that you don't take that path because I do not believe you would prevail. And again, that's not just my legal advice, but I spoke to a great length with Mike Saystad at NACO about this issue and with another private attorney who has a great deal more contract experience than I do. I just don't think we have a leg to stand on, and we're in a much better position by working in a friendly manner with Teamsters to resolve the concerns, but we are going to have a bill to pay. The other issue I wanted to just touch on that I considered in looking at all of this is, from my understanding about the policies that we had prior through MACO and other coverage that would be available to us, this is still dollar for dollar the best value for our employees. It's pretty much a platinum coverage for a very reasonable rate. So it's not like looking at the things that they're asking us to comply with in terms of their standard contracting. There's not really any reason for us. There's not really any big financial incentive for us to say, well, forget it, we're going to go with somebody. Apparently, I'm assuming that MACO agreed to the terms that we had in the past with regard to how to apply coverage to part-time, temporary, seasonal employees. I don't think that the benefit, we have so few of those in the overall scope of things, that the benefit of having our way in regard to that issue does not outweigh the benefit of staying with Teamsters as our coverage going forward.
I'm the third person.
Oh, well, actually, you must be a fourth,
Oh,
but
okay.
you were not one that came up in you guys are part-time though.
We're exempt.
So you're
As
exempt
electives,
anyway,
yeah.
right? No, this was another full-time employee, and I'm not gonna name names just because
Right.
it's not proper in a public meeting, but I think probably as a matter of institutional knowledge, you probably know who the two right now are that don't have coverage through Teamsters and,
Well, and I've had lots of health problems, including open heart surgery when I was at the state, and I felt obligated, really. They covered me very well with all my surgeries. And so I stayed with the state. It comes right out of my retirement. every month.
And
Is it
they also
atrocious?
have,
Yes.
they also have a very good policy. It is not quite as generous as Teamsters. I will miss it myself. But I was actually very pleased to see that under the new ACA, I will get a very similar policy, slightly higher deductible, but much lower monthly premium. Maybe someday the availability of that system will take this burden off of employers going forward, but we'll see about that. Do you have questions about this process? And I will put together a handout so that you have sort of a summary of everything at the time that I can present you a specific dollar figure, because I knew I didn't have that information today. I thought we'd just have a chat about the history and what I've been working on since January to try to resolve this and minimize the financial exposure of the county. But
I do have a question, Carla. I know you don't have anything back from Teamsters to be able to give us a solid number, but the $115,997 was shocking. What
Yeah.
what ballpark are we targeting right now, or how much has been taken off of that
I think it's
due
been,
to errors?
I think it's been more than halved, is my understanding. The last, Ms. Dworsky and I are very good attorneys, but we're not mathematicians, and so we were kind of giggling a little bit about that in our last meeting, that, we know it's been reduced significantly. She has to look at the numbers again. She's been having her staff work on, the actual numbers as things have been whittled down, but I would say that we're probably gonna be looking at less than half that amount. I
Okay.
hope, that is certainly my hope.
These problems have all been corrected, I hope.
Again, as I said, Debbie is aware, and assuming, again, the only questions that are outstanding are, will Teamsters allow the employees who right now do not contribute or participate to be grandfathered and to continue in that status going forward? Both of them are very anxious to be able to do that, because obviously our policy is nothing but a benefit that they don't have any need for when their spouses already have very good coverage that they're participants in. And will they consider giving us that same grace backwards on the employee who we can't reach? I asked Ms. Dworsky in our last email communication about a week ago, would it be helpful if we tried to send like a certified delivery receipt letter to see if we could get a hold. It's quite possible this lady is retirement age and above, and I don't even know. I did check to see if I could find an obituary or a listing in the Social Security Index that she had passed away, and I couldn't. So presumably she's still out there, but it's just an issue of finding her and assuming that she'd be willing to call whoever her provider was at the time, because presumably now she's covered through retirement coverage and Medicare, that she would be able to get proof in writing, which the other two employees did, that they had coverage and their coverage is still effective. In her case, it would just be for the period of time that was audited. Up until, I think she actually terminated employment with the county halfway through the audit period. So our exposure on her is much less than it was on the other two employees who are still employed. But as far as, I don't think that there's gonna be any possibility that they're going to agree to the way we have calculated part-time seasonal temporary employees, which, what it gets down to is this: we had looked at an overall, how many hours did they work in the period that they were employed, and like an average versus their position is if you work 32 hours a week or more in 1 week of a pay period, then you're under their contract and their guidelines, you have to participate. So, and they're not gonna be flexible on that.
You can imagine the accounting nightmare for that one.
So, did I answer the question?
You did,
Okay.
thank you. I just didn't want that $115,997 to sit out there as the,
Yeah, well, it's a
That's-
scary
was the
number,
it
you know,
is,
but
yeah.
the fact is, again, I mean, I'm not gonna make judgment. I know that the folks that I've worked with here were following direction that they had been given, and it was all good faith error. There was no attempt to defraud or intentionally or willfully violate the terms of our agreement with Teamsters. My advice going forward, obviously, again, is, and I've been saying it for the entire 2.5 years I've been here, that whenever you engage in any kind of conversation about terms of agreements of any kind, you really need to document that, even if it's just as much as, archiving your email and having that available to look at in the future when necessary. But certainly, and another issue, and Corey and I are going to be meeting later today to talk about some issues with the county attorney's office, but one of the issues that I guess I've already sent a memo to you folks within the past month or two, and I would just reiterate on my way out the door, is that you need to provide the county attorney's office with the opportunity to review every single contract that the county engages in. I have no record in my office as to whether Mr. Flynn was provided the opportunity to review this contract. The upside, if you don't provide the opportunity to the county attorney, is he can say, they messed up, wasn't my fault. They didn't give me an opportunity to give them legal advice and guidance. So the upside to you is put it on the county attorney's office. If he isn't able to, for whatever reason, because of workload, that's why there's budgetary line item for contracting out work, and Mr. Flynn did that on a fairly regular basis. I've only done it a few times, but those, there is a resource available through the county attorney's office for the commissioner or any other department to get legal advice, review, guidance in a contracting process. And if you don't avail yourself of that, then it's going to fall on, the county's still gonna have to deal with whatever mess is created by a failure to have that contract vetted. But it certainly isn't something that the county attorney would be responsible for. He would just have to clean up the mess. So I think as a matter of courtesy, please give me the opportunity to be involved in every contract, and please make it clear to other department heads that, I wanna say that most of the department heads have been really great about, can you look at this contract for me? I just looked at one for the county nurse a week ago, so that hasn't really been an issue, but I think there has been an issue in the past with certain things being negotiated and engaged in on a contractual basis through accounting without involvement of the county attorney's office. As far as I can see, there's no record in that office, and there's no record in my office that this particular and other issues that we've discussed with regard to reserve deputy, et cetera, CBAs that involved, salary schedules that are contrary to MCA. I know at least in the very last iteration of that, we had private counsel to blame for getting us into that mess. The iteration before, it's not clear to me from either direction with regard to the records whether the county attorney had a hand in that or not, but let's just say that it's a new day, and going forward, let's be very diligent about allowing the legal department to be the resource that it is for the county, so that any kinds of issues like this can hopefully be avoided from the front end.
Is this something that our insurance would be taking care of?
No. We wouldn't have coverage for our failure to comply with a contract. There's really, although our failure was good faith in the sense that it was a genuine, honest misunderstanding of the people who were engaging in the payroll process and making the contributions, I don't believe there's any basis for us to be covered by that. If we were sued by them, it's possible that but that's why I reached out to Mr. Seystad pretty much right after we got the letter in January to discuss what I had found in the records and in looking through our files, and we both agreed that there's just really no defense for the county here. So we're better off. The added cost of litigation would be, we would end up with a bill probably twice as much, so. And we don't want to, I guess, in any way tarnish the good relationship that we have with this very large vendor with whom we contract either.
Well, if we owe it, we owe it.
This is, just to make that clear, this is money we would have paid if we had been following the contract properly. So it's like we got a loan there, and now we have to pay the loan back. We didn't intentionally get a loan from Teamsters, which is why I asked them to show as much good grace toward us as possible as the law allows, and reducing the interest that we would be charged and the liquidated damages. And I hope that it sounds like from my last conversation with Ms. Dworsky, that she feels that they are likely to be generous in that regard. But it's not like, it's kind of similar in a way to the situation we had shortly after I got here, where we realized that there had been a good faith, honest math error in the clerk and recorder's office with regard to tax withholding to the schools.
Oh, yeah.
I mean, that money was owed to the schools from the beginning, we just didn't do it right, so we had it in our pocket, and then we had to give it to them. But it's not like a bill that we never had, that suddenly we're getting hit with a bill we never had. We just made a mistake, and, you know, I think it's important. I know there's been a lot of allegations and this and that in the past couple of years, but I think it's important that we recognize that governments are made up of human beings, and human beings make mistakes. My perception of the folks here is that everybody works really hard and tries really hard to do the right thing all the time and to do their jobs correctly, but everybody makes mistakes. Errors like that happen in municipalities all over the country, I'm sure all over the world. You know, and it really isn't worth getting into a blame game, because, I mean, I know there are certain individuals who will do that because that's just how certain people are, but the fact is that a mistake was made. We're doing what we need to rectify it and make sure that it isn't made going forward.
Michelle Quigley just said something that I think piggybacks on what you were saying. We were coming out of the mediation with Teamsters over the wage disparity. And Michelle said, well, the good thing for you to know is when this is over with, there'll just be another mess to clean up. She said it's the nature of business.
Right.
So,
I mean,
yeah.
you wouldn't need a legal department other than a prosecutor to prosecute crime. You wouldn't need a county attorney to do civil work if you didn't have issues. And to some degree, again, my encouragement is to keep working proactively, maybe more so than in the time I've been here with the county attorney's office, to give him the opportunity to avoid as many, you know, possible messes as he can. But he's only human too, and lawyers make mistakes as well. I mean, we know that from the private counsel that we hired in the last CBA negotiation. So, you know, there is no such thing as perfection. We all, I guess, try to some degree to achieve that, but it's important to understand that, you know, absent willful misconduct or malpractice, and I guess I'm not gonna really speak to what happened there with the CBA and private counsel, but I think I've shared with the commission already the opinion that Mike shared with me, that there isn't a lot of benefit at this point in trying to go backwards and point fingers at the attorney that you hired and the mistake that was made. I mean, there are processes for complaining, et cetera, but there really isn't a lot that comes out of that. And honestly, although it's been kind of a headache, and right now we're facing litigation day after the election in somewhat based on that issue, the financial exposure, the financial damage is so minimal that there's really not a harm that can be alleged in order to make the process of pursuing a complaint really fruitful.
Well, and I don't find this to be Debbie's problem, for what you're reading to us. And
Oh,
telling us.
no, she followed, you know, at the time that this was negotiated and entered into in 2009, she was just an accounting clerk, I believe, at that point.
Yeah, she was just payroll.
Mhm.
Yep.
So, you know, Ms. Wenzel directed her, this is how you calculate, and this is who is qualified or required to contribute, be participating in the plan, and these are the folks who aren't. And she just followed that to the letter. And unfortunately, the advice wasn't appropriate. And I don't, you know, absent a conversation with Ms. Wenzel, I don't know whether she just misunderstood. I don't know what went on in her head or, you know, to lead to that discrepancy between the county's understanding and Teamsters' understanding. And Teamsters' position is much more supported by the plain language of the contract we signed than our position. And that's why, you know, my advice is that we pay the money we should have paid in the first place and go forward with understanding our contract better. at this
And
point.
document.
Yes.
Yeah,
And some more.
right,
Yes, times 4.
yeah.
Any more questions about that?
Not from me, no. As far as next week's agenda, if you would just let me know what language you want on the agenda.
I would
I'll get it
ask
on there.
that you, and again, I will let you know, hopefully by the end of today. I sent an email to Ms. Dorsey over the weekend, don't have a response yet, but I expect one today. If for some reason she doesn't have an answer yet, but the last time I communicated with her about a week and a half ago, she was apologizing for the delay and saying she was gonna be getting an answer to me. So I would say put it on the agenda the way it was, with the clear indication that there's gonna be a vote or decision.
Okay,
Essentially, it's a vote or decision to pay the bill or to not follow legal advice, and then, I would have to say, you know, my office does not, well, it would be to some degree Mr. Swanson's decision as well, but I don't think, my position is the office doesn't have the resources to litigate a civil action at that level. It would have to be contracted out to private counsel, and since you would be doing so against the advice of the county attorney's office, I think that would be something that the commission would have to,
That'd be foolish.
I agree, that's my position as well, but,
If we ought, we ought.
thank you very much.
Next time I want you to come with good news, so.
Well, I think that getting the 115.9 down to
Yeah.
60, give or take, is
hopefully,
good news.
it's better news than it could have been. I guess it's
Exactly.
that.
That's right.
Everything's relative. Yeah. Any questions anyone has on this? All right. Any more questions from the board? Corey, you kind of look like a sponge. Any questions?
Oh, I'll have to review that whole file and go from there,
Yeah.
so.
And, you know, Debbie's available too if you have any questions on that. I know she'd be more than happy to talk to you about it. As would any employee if you want to talk to anybody.
I guess, just on that note, I mean, I'm happy to talk with Corey, in addition to the other things we're talking about later this afternoon, about this file and the reasons why I came to the decisions I did, but my legal advice governs until December 31st at midnight. So and you need to be aware that, you know, interest during this process, one of the decisions that I, you know, made clear to Ms. Dworsky I understood was that interest would continue to accrue while we worked through this negotiation process. If the commission wants to wait to get Mr. Swanson's opinion and take his advice rather than mine, that's perfectly fine with me, but just be aware, if you choose to do that, you know, you could set the agenda item for sometime in January. I'll share the number with him and let Ms. Dworsky know we're not gonna act on it until he comes into office, but just be aware that there would be additional interest that accrues in that time period. I would think it would be strange if he had a different opinion than mine and Mr. Staysdad's and the other private attorney that we both discussed it with, but this is one of those awkward places where, because there's gonna be a change in the legal department, I guess you have to make a decision about whether you wanna follow the advice you have before you now or whether you wanna wait, so just let me know. I don't care either way.
On
Other than
that-
as a taxpayer, I hate to see the bill get any bigger, but.
Right. On that, Corey, you sent a very eloquent memo regarding this issue. Did you want to address any of that?
No,
as
well,
far as
not
the
this
transition?
issue, I didn't know anything about it, but in general, the transition that, like I'm here today and I'll be here tomorrow, meeting with people, looking at stuff, but anything that's of official nature of any kind, up until I'm sworn in, I'm just a private citizen still, and Carla's a county attorney, so, you know, if I'm asked to comment, I probably won't. I'll probably just review stuff and gather information, and then when I'm responsible, then I'm accountable for my legal advice. So until that happens, I would urge you to, you know, certainly I wanna be able to have an open door and meet with all of you, whether to collectively or individually, learn more about what goes on and, you know, all the files, whether they're civil or criminal, we have open, all the processes that we're doing, but in terms of, I don't have legal authority to be the county attorney at this point. Carla is until I'm sworn in and that transition happens, and so just urge you to, if you wanna copy me on things, that's fine, but I will be very, I'll close mouth and open ears until that happens.
Thank you. Any other questions? All right,
Eleanor, you just our time, I apologize for putting you off schedule.
that was an important issue, so
Yes.
that's okay.
Hopefully the next meeting, I mean, and again, just let me know, if you wanna put it on for next week, I'll certainly let you know if I have an answer from Ms. Gorski. If you wanna put it off, just let me know.
Okay,
All right,
all right,
thanks, guys.
thank you. Next on the agenda is Nicole Brown, County Planner, Townsend Mobile Home Estates, request final plat approval decision.
How are you?
Good, how are you doing?
Good, really good.
Good, I'm glad.
You got a pocket?
Do I have a pocket? Oh, thank you, I'm going for it to give it to you. Bless your heart, thank you. So this is
One
the,
more.
Just like sisters, we share jewelry and sweaters.
this is the Townsend Mobile Home Estates. This is a plan, not a plat. As you may or may not be aware, with the legislative changes that occurred that created the buildings for lease or rent, from here on out, mobile home parks will go through with a plat. It'll be exactly like a subdivision. This one was submitted with our old regulations. So anyway, this is a plan, not a plat, just for the record.
Thank you.
So this is the request for final approval. Yes. Let's
Is that
see.
the one right here in the north end of town?
Yep, and this is Canton and Mill here.
Right behind the microphone.
Yeah.
So I'll just start here, pass them around if that's okay.
Perfect.
Yeah, one trailer in there now.
They do, and they're working on finalizing this, that probably shouldn't have been put in. And
Oh.
Julie is aware of it, Carla's aware of it, the owner of the property is aware of it, so they're really hurrying to get this final, so it's all legal. But everything is here. So anyway, I'm just going to read over this and then the documents will come around. Number 1, plans for sewage treatment and water supply shall be submitted to Montana Department of Environmental Quality and Broadwater County Environmental Health Department for review and approval. The certificate of subdivision approval shall be filed with the final plan. So you have the approved, or the DEQ approval there. Number 2, this is number 1 and 3, this is number 2. So I'll just go slow here so you can each have an opportunity to look through it. So remember what you're looking at for number 1, this is 1 and 3.
This is new.
This is new.
Yeah.
And I'll explain that here. Number 2, the developer must verify that the existing county road, Canton Lane, because that's where they're shuffling traffic out of, will meet the Broadwater County subdivision road standards for vehicle trips per day at its current condition. So what the developer had hired Shaver Surveying, Bernadette, to do this traffic count. So peak times went out there and counted traffic, just to verify that it's not going to change that subdivision road standard. We could assume, because this is a number 2 local road, it's a paved surface, can hold up to, I believe, 1,800 vehicle trips per day. This development should not have put it over that. We just needed to verify that so that we could meet that condition. So she had to sit and count cars a couple of days at peak traffic times. So,
Was that at the direction of the planning board?
yes, it was.
Okay, all right.
Yep, yeah, just to verify that, it's difficult to tell. It really is, that Canton Lane that serves a lot of the east side of the county. I know some folks, I don't know if you take that when you're coming in, if you cross Delger and take that, people could either take the highway 284 to 12, they could cut across Delger and come down there. So it's really difficult to quantify that as opposed to maybe another development, say Wheatland Road, because there's a finite amount of traffic that could use this. Canton Lane could be infinite, but just to verify that, we had to do a traffic count.
I like that very much. I like the fact that you're not assuming. Can I ask one request in the
Certainly.
future? Could we have letterhead so we know where it comes from? It just gives it a little bit more credibility.
Definitely,
Okay.
definitely. Make a note of that. And so number 3 was part of the DEQ approval. A stormwater drainage plan meeting the requirements of county subdivision regulations shall be submitted to the county planning department for review and recommendation. So the drainage plan is part of the DEQ approval. Number 4 Prior to any development and or soil disturbance, a weed management plan for the proposed development shall be submitted to County Weed District for review and approval. So there is the signed and approved weed management plan. Five. Prior to any development, 2 approach permits shall be requested from the county road department for the 2 access points off of Canton Lane. So, one form, that there are 2 signed pages by Dana, noting that there are the 2 approaches there. Number 6, I don't have a document for you, but number 6 states an exterior boundary fence shall be installed around the perimeter of the property. And that fence is it. Number 7, a pedestrian easement shall be added to the final plat to allow for connectivity to the existing Mountain View Mobile Home Park to the north. And there is an easement, a 10-foot pedestrian
In
easement.
the back part there, right?
Yep.
Right there?
Yep, right in here. 15-foot pedestrian easement, shown
Nice.
right there. And that's basically, I don't know if you recall, we talked about this at preliminary, when they were requesting preliminary for kiddos, or anybody, and for that matter, but, we're not looking to funnel traffic through there, that's why it's only a 15-foot pedestrian, so if you've got neighborhood kids that want to play back and forth. This development has a park area designated in it, just some open space, so we certainly don't want these kids in the connecting mobile home park to have to funnel out onto one of these busier roads with all of that truck traffic, so just that would make a smart planning essentially to keep all that traffic within those boundary fences.
Yeah, it's a good move.
Number 8, the applicant shall be required to submit preliminary plan and final plan drawings in electronic format, and they have done so. Number 9, I'll let it here for you.
Thank you.
Plans for the location and installation of individual mailboxes shall be reviewed and approved by the U.S. Postal Service prior to installation. Letter from Gail, Postmaster.
Hi, is Gail Boucher, is she the postmaster here?
Apparently, yeah, I didn't know
I
this
thought
either.
that other lady was.
Yeah, I did too, but,
I guess we learned something.
okay, right, yeah.
Who's that?
Gail Bruchet
Oh,
from, the south, obviously, from here,
From
neighborhood
Charleston.
there, yeah.
Interesting.
Number 10, this is the approved fire plan. The fire department requested the $100 per lot, and so there's a check for $1,500 there that I'll deposit into the Broadwater Rural Fire District.
This is 8,500.
85, I'm sorry, 8,500, I was looking at it upside down. I'm sure they would have liked to have paid $1,500. It's $500 per lot, sorry.
How will that change with the lease and rent legislation?
They will still have to have a fire plan. So it'll still be up to the fire department, or the fire board, I should say.
Would they be well advised to have a plan specific to the rent and lease?
That might be a good idea, because right now, again, this was under the old regulations, where it's the $500 per lot. New regulations are $1,000 per lot. So, that's gonna change significantly for a lot of folks moving forward. Especially developments of this size, they kind of fall in that in-between area where, $1,000 per lot, that would be a significant amount of money. However, still less than providing a place for a dry hydrant or a tank or something like that. So I think as we move forward, it's gonna be interesting. This 500 is a little bit easier to swallow, or was, but, we worked through this, and it was all part of the public process to change these regulations, these fire regulations, and, so I think that you're right. I think I should probably seek legal counsel either here or with Susan and find out if the fire department should be on board, even though we don't necessarily advise the fire department, or the fire board, I should say. I should probably make them aware of that. 11A and B, this is concerning roads, sorry, I think I might have something else attached there, I do. 11A, the applicant shall complete the following for construction of the internal access road. Prior to the construction of any roads or the installation of any utilities, plans for the subject road and utilities shall be submitted to the county planning department. So you have the road plans, and 11B states improve the internal access road to the specification